Kia ora tātou katoa. I have the honour today of chairing the final session. Now, after Dame Claudia Orange's elegant introduction of Sir Geoffrey yesterday, I feel too shamed to say simply that these four eminent jurists need no introduction. So let me summarise their careers as follows. Sir Ken Keith wrote much of New Zealand's constitution in various capacities before becoming New Zealand's first judge on the ICJ. Sir Geoffrey wrote all the other bits, both before and after being the Prime Minister of New Zealand. Professor Philip Joseph has authored New Zealand's leading textbook on constitutional and administrative law, causing me the awkward difficulty each year of having to shove as much of it into my materials as possible while evading copyright laws.
I will do.
And Professor A.T.H. Smith has been Dean or Chairperson of so many leading law faculties that I've actually lost count, in between authoring numerous eminent textbooks, and most challengingly has managed to corral the unruly members of the Victoria University of Wellington Law Faculty into something approaching order. Now, this is a fairly informal session. The speakers are going to speak in the order in which they're sitting. Each of them will speak for around 10 minutes, just making some reflections on the themes of the conference. And after that, we hope that there'll be lots of time for some interactive discussion about what's on your mind in terms of what's taken place over the last couple of days. So on that note, I'm going to hand over to Sir Kenneth Keith.
Well, thanks very much, Claudia, and it's great to be here and with such a great audience and such a lot of great discussion. I think Tony's got the hardest constitutional job. I did his job for a while, and trying to do whatever you're supposed to do as Dean of a law faculty is really difficult compared with a lot of the stuff we're talking about. Now, we've had much valuable discussion in the last couple of days. I've learned a great deal. And one sense I get is that there's still a whole lot more research to be done, and that's an encouraging thought. I've got 3 or 4 themes that I'd run through quickly, and then I've just got a final reflection and one point of part omission too, I think, in the program. The first theme is the role of principle or of values, which I think has been well emphasised throughout the couple of days. I was really taken with a couple of the Maori papers, Cowan and Mamari, for instance. There is then the real contribution of principle from James Stephen and his colleagues and all the influences on them in the Colonial Office. And then after that, as we've just heard from Peter Mackenzie, there's Chief Justice Martin. And around the same time, I think you find Henry Sewell, the first briefly Premier of New Zealand, talking about the same thing. And it's interesting, quite apart from the emphasis on Christian principle and other principles of humanitarian kind there, to find those people going back to Vattel, as Peter mentioned, to Chief Justice Marshall, and so on, to appealing to well-established principle and practice. One of the things I read recently references to the French practice in Algeria, for instance. So there's that beginning of principle and of values. 1893 is another critical time in terms of the recognition of that for all kinds of reasons. There's universal suffrage, and in terms of the Chief Justice's exchange with her South African friend that she mentioned, we can, I think, claim to be the oldest democracy in terms of general suffrage. But in 1893 as well, we got the secret ballot, we got provision for fair boundary setting to avoid gerrymandering, and we also got, thinking of fairness, we got, I think it's 1893, the Old Age Pension Act, which has a preamble which talks about fairness in terms of the proposition that you people have contributed to the building up of this country, and therefore you should be entitled to an old age pension so long as you're not Chinese, actually, it also said, and you're of good sober habits and so on. So and at the same time, of course, there was all the very important legislation in the employment area, the Industrial Conciliation and Arbitration Act, factories legislation, and so on. Then, I'm thinking of the great paper this morning from Professor Fisher, there were further developments, and let me just pick out one date on the way to the 1960s. I think one critical date in terms of fairness is the Social Security Act of 1938. And thinking of the discussion about freedom and fairness, I think it's interesting to look back to Roosevelt's four freedoms, because in some ways they're about fairness as well. The freedom from want is about fairness as much as it is about freedom. It's a question of quite how you use some of these words. But then I was thinking in terms of the last session of the amazing constitutional changes over the last 50 years, because if you go back to 1962, you've got the beginning of the Ombudsman, and here we get into foreign borrowings. There was a question to Geoff Macleay about that, and we've done it, I think, pretty carefully and pretty well. We've picked up on ideas from elsewhere that seem to work here with appropriate adaptations. So the Ombudsman is one, official information is another, with the emphasis there on openness, on transparency. The Bill of Rights another, and then the changes to the electoral system, which came by way of German ideas, but with a whole lot of other influences in terms of democracy, but also in terms of the protection of minorities, because in that report of the Electoral Commission you'll find in Chapter 3 quite a lot of discussion about how to deal with treaty issues, with the Maori issues, and what should be done about all of that. Now, through all of that, I think, as opposed to the number 8 fencing wire proposition, and number 8 fencing wire is actually principled and sensible in many contexts, as opposed to that kind of view of our constitution, there's been a lot of constitutional and legal development which is very principled, which is aimed at a fairer deal, which is aimed at a stronger democracy, and a democracy which is supported, a system which is supported by good principle. If I could just say a quick word about the rule of law in this context. The United Kingdom Constitutional Reform Act, I think it's called, the one that set up their Supreme Court, actually has a formal statement requiring ministers to help maintain the rule of law. You sometimes wonder about that when you see some of the attacks in the British press by ministers on what is being done by the Supreme Court or what is being done by the European Court of Human Rights, because that obligation, you've got a substantive reference to the rule of law and the independence of the judiciary. That substantive obligation is one which extends to international courts. That extends, I realised when I read it, to me, because it relates to any international court to which the United Kingdom is involved. Just another quick point on the rule of law. There's been a huge amount of discussion about it in the United Nations over the last 5 years now, I think. And this time last year there was a major meeting at the beginning of the General Assembly in which a declaration is unanimously adopted on the rule of law, and it gives a lot of substantive content, a lot of reference to substantive rights under the international human rights instruments and the like. And so that's a thick definition as opposed to Matthew's rather thinner and formalist definition of the rule of law. So there's a whole lot of practice there that may be worth looking at. New Zealand has, on a number of occasions, I think, responded to requests for information about what's happening here on that heading. And just before we came back for our so-called summer holiday here, a very bright young New Zealander who had been my last law clerk here came in. She's now working in the Rule of Law Unit in the UN Secretariat in New York. She's previously had 5-6 years, which she said were fantastic, working in the nitty-gritty of getting the rule of law to work in Liberia. So there's a lot of stuff around about those principles and values. And then it's important, I think, second, to take the point that they're at work in all areas of government, not just, it's an important point that Geoff Macleay made, not just or mainly in the courts. It's really important that we get a proper sense of how these things work, thinking of another of Matthew's papers, and through all the office holders, through the public service, through the Cabinet Office, through Crown Law, other government lawyers, the Audit Office, the Ombudsman, the Parliamentary Council Office, and so on. There are all those people as well who have to make sure that principle is reflected and taken into account, and that they give free and frank advice about that, and in that context, a very good career, non-corrupt public service is critical. Now, third, much of that material can be relevant as well in judging. I was trying to think of instances where the rule of law might have been used in judgments that I was party to here, but we referred a number of times to the principle of legality, for instance, sometimes in the context of retrospective legislation. Certainly quite a bit at times about the rights of Maori, distinctions between dominium and imperium, thinking of the foreshore and seabed ruckus, where again we went back to Vattel, I think, and other people further back into treaty language. And so the courts do refer to these principles, even if they may not be specifically applicable in terms of the Bill of Rights. I'll just make a process point and then I'll refer to what I thought of as one possible omission in all this discussion. The process point, I think, is critical. It's something that's been emphasised often. We're engaged, any society is engaged in a process of redevelopment, reinvention, constitutional reform, economic reform, social reform, lots of changes, and we need to have good processes for doing that. We need to have processes that properly weigh the factors, that properly weigh the considerations, and sometimes those processes have to be processes that take proper account of special interests, special rights, or the special category of legislation, for instance. It is important that a certain range of things be done by broad agreement among the political parties. Sometimes matters must also go to the people in terms of referendums. Sometimes a regular parliamentary process will be enough, but I think we need to have a real sense of manner and form, an expression that Janet used at one point earlier. And you'll find some discussion of the varying ways, for instance, in which treaty issues, Maori issues, should be handled, whether simply by simple majority or by special agreement or by autonomy or by some variation on subsidiarity or whatever it might be. We need to be careful about the right processes. One of my heroes in the Legal Academy is Lon Fuller, and the most recent book about him is called Forms Liberate. Forms Liberate, on the basis that if you get the procedures right, you'll very often get much more satisfactory decisions. My last point is about a possible omission, and that is, although there's been reference to human rights treaties, there's been almost, so far as I'm aware, I couldn't get to every session, they were running in parallel, so far as I'm aware, there has been no reference to a huge body of other law. I think a third or a quarter or something of our statutes are affected by international law. With all respect to those who talk about the sovereignty of Parliament, there is no such thing anywhere in the world. No country is sovereign. I'm going to depend tomorrow on airlines flying, not according to New Zealand law or New South Wales law or a bit later Japanese law or wherever we travel next. We need international law dealing with that. And I think we have to recognise that in this globalising world, which did get a few references, where I think 1/2000th of the world's population, we're somewhat larger than that in terms of trade, international trade, but still, we are so dependent on the world, and so much of our law is affected by international law. And one of the things I think that needs more attention, it was discussed in this room at a conference a few years ago, is the way in which New Zealanders engage, or too often don't engage, in the making of that law. Parliamentary procedures for acceptance of treaties have built up, but the earlier phase of the negotiation of agenda setting is critically important. So I think there is that big area that we need to give more attention to, but I've been very grateful to have been here for the last couple of days, and thanks very much to the organisers for a great event. Thank you.
May I begin by just offering my warm congratulations to our chair on acquiring her chair. Claudia, warm congratulations. It's the first opportunity I've had actually to say to Claudia personally, well done, and it's well deserved. The second thing I'd like to mention is actually the centre itself, the New Zealand Centre for Public Law. It does a wonderful job in keeping alive these constitutional discussions, discussions which I believe are becoming much more insistent over the last 20 years. It's my theory that, in fact, New Zealand has actually spun out of a certain period into another, and I identify this as one of national introspection, where we're now visiting, I don't say revisiting, I say visiting for the first time, our constitutional foundations. And I thought that the last session was remarkable, actually, in probing those issues which actually we're going to have to face up to within the next few years, I suggest. So I want to say I'm going to depart from the normal disciplines that apply to a rapporteur. My good friend Ken here actually did touch upon some of the themes that have been touched upon by our speakers, but I intend to depart, and I hope you forgive me. But I will say that there have been, over these last 2 days, a number of strains which have come through the various presentations, various narratives flowing throughout New Zealand's constitutional journey. Now, it's interesting that the conference itself is titled Uncovering New Zealand's Constitutional Traditions, in the plural, not the singular, because tracing New Zealand's constitutional journey, there's just not one story, one narrative. In fact, there are several, but these stories do not travel in parallel. They are forever intersecting and weaving their magic. And I'd just like to identify perhaps 3 such stories or narratives, and the first one actually goes back to our constitutional origins, in fact, Crown Colony experience. Now, it's something we might not wish to embrace wholeheartedly in 2013, but we are forever actually part of that colonial constitutional experience. And if I might just refer to the Constitution Act of 1986, one of Geoffrey's lasting contributions. Now, that act actually preserves almost 100% intact our colonial constitutional experience. It is not a constitutive instrument. It's one of our foremost premier constitutional documents, but it is wholly declaratory. So if you go to, for example, section 14, it says there shall continue to be the Parliament of New Zealand. It doesn't create it, it simply carries it over. And then section 15 says that the Parliament of New Zealand shall continue to have full powers of legislation. So if we want to make sense of our constitutional arrangements today, in 2013, we've got to actually travel back in time. We've got to go back to the 1852 Constitution Act. Now, there is an irony in itself, because that act is no longer law. It was repealed by Geoffrey's legislation. And yet, to make sense of that statute, we've got to go back and look at the creations of our parliamentary system, sections 32 and 53 of that act, create our parliament and actually give it its law-making power. And that power is being exercised in this House today, actually, when Parliament passes legislation. So it's a good indication, really, that we have not managed to escape our colonial constitutional experience. It is forever with us, forever speaking. Now, with that, we must immediately then turn, I think, to the Maori constitutional life of this country, which is becoming much more prominent and to the forefront. It's a rich contribution, and in some sense it's also a rich counterpoint to that colonial constitutional experience. And I think it's this which makes the New Zealand constitutional experience unique, and it is. It's the treaty. And the idea of biculturalism, which underpins all of our public arrangements today. But if we might just turn back the clock and just think about the role of the treaty actually in this country's life. It was brilliantly embraced way back in 1847 with that outstanding decision in Simon's case, with Justices Martin and Chapman when they embraced the idea of Maori traditional rights as being embodied in Article 2 of the treaty. And then 30 years forward, we lose all of that with that wonderful decision called Wiparata, where, of course, the treaty was dismissed as a mere nullity. And then it just disappeared from the national consciousness. It was no longer a source of any national pride. It simply waned. In fact, when I went through as an undergraduate many, many years ago, I was not told about the treaty. But today, it's to the forefront of any public law course in this country. And so, of course, that all happened principally with that iconic decision in the Lands case in 1986. And that really charts, I think, the future of New Zealand today. And we heard a number of presentations actually addressing the Māori constitutional dimension, or indeed, as Jones said, I beg your pardon, I think in the plural, traditions, not just simply one tradition, because it's a contested history. If we might move on to our third story, which actually intersects with those two other narratives, and this is something we might not wish to embrace wholeheartedly, and I think Ken touched upon it with the idea of the piece of number 8 wire. But this intersecting story is one which we might identify as constitutional pragmatism. It's a pragmatism which really borders on indifference. And you might remember Peter Dunn's Select Committee, which reported in 2005, the Constitutional Arrangements Committee, and there was one phrase which summed up New Zealand's constitutional journey, and that was pragmatic evolution. And it captures the idea of this underlying pragmatism which has been part of the New Zealand story, the national story. And if I might just give you an example of that, of just not so long ago, in 1970, there was an amendment to the Constitution Act. Now, it's not a widely acclaimed amendment to the Constitution Act, but I think it was very revealing because this amendment to the Constitution Act finally repealed the requirement that to change the Governor-General's salary, that bill had to be reserved for Her Majesty's assent. Now, that was simply ignored from 1957 through to 1970 on 4 occasions. And then someone sort of woke up one day in Wellington and scratched their head and said, well, I think we'd better do something about this. So they finally got round to repealing the requirement. But they post-dated it back to 1957 to take account of all these statutes which have been passed with complete indifference for constitutional principle. So I think it actually is a fairly good window of this indifference to our constitutional arrangements, and it is indeed a defining characteristic. If I might just dwell on that for a moment. Now, our developments have not been moved by doctrines, theories, or principles. They haven't been. And if you cast your mind back to, well, the first great period of social transition in this country from 1890, this was under the first Liberal government elected in 1890, and of course it was remembered for the very progressive legislative reforms of that period. Ken mentioned one in 1893, we gave women the vote. That was a pretty big deal. In 1894, we had the Industrial Conciliation and Arbitration legislation, which our Australian cousins have since adopted, and unfortunately they still have to operate under. We've moved on, but that was a very progressive measure. And there was factory legislation. I think Ken mentioned the pensions legislation. And so New Zealand became the land of the daring experiment. But the point being, and this is what international observers saw, is that it was not driven by any concept of Fabian socialism, any concept of progressive theories or doctrines or principles. These were simply people who were sort of plucked from ordinary life, and they became leaders of our country, Balance and Seddon. And William Pember Reeves, perhaps the only one of the Seddon cabinet that was educated, really, actually reflected on his cabinet colleagues and said, well, they weren't driven by any concept of state socialism, and if they'd really understood its tenets, they would have much liked it anyway. So they're empiricists, not theorists, and that's the first thing. And I probably don't have much time, but I think the other two great periods of New Zealand's constitutional journey would be from 1935 with the establishment of the welfare state. Now, this again, Michael Joseph Savage said, this was not driven by any sense of state socialism. It was simply humanitarian response to the miseries of the Depression. And so we built the welfare state not on any, again, concept of theory, principle, doctrine. And I think we might move through to Geoffrey's time, if we might, from 1984 to 1990, the third great period of social and economic transition in this country. And again, I just discussed with Geoffrey before the session, and Rogernomics was not driven by any deep sort of theory or concept of how we ought to govern ourselves. It was a response to needs. There was an imbalance caused by the intensive central economic planning of the Muldoon years. And as Geoffrey said in his sort of typical way, we had no money, so we had to do something. That'd be a correct summation, wouldn't it? Yeah. So that's our third story, the idea that, you know, we are still driven by the sense of, you know, number 8 wire, and that's our third sort of prong, if you like, to this tripod of the narratives of stories. And our fourth story really is the combination of these intersecting narratives. I think that produces a distinctive New Zealand way, a distinctive national culture. And in this national culture or character, there's an odd trait really that I was just thinking about before I came in. It's a sort of larrikin spirit that made us in the 1890s this land of the daring experiment, and that sort of sense of larrikin sort of underpins us today. What caused us 20 years ago in 1993 to experiment with this utterly novel electoral system called MMP? Now, none of us really understood it, because when we voted for it in 1993, we woke up to a hung parliament. We said, look, constitutional crisis. And it's the stuff of MMP, the stuff that people voted for. But there was this sort of a sense that we need to do something, let's just go with it. So that larrikinism sort of underpins our national culture still today. And what really makes us pretty novel. So to sum up, we're a pretty unassuming, modest lot, I think. People, but are people with a fairly proud story to tell, and that's been told over these last 2 days. A story that can't be reduced to a few pithy words, no matter our best attempts. But I think we all embrace the feeling, or the vibe, as our Australian cousins would say, that there is a rich national culture unfolding, something about which we can feel slightly proud. And I think I'd just like to end by referring back to that last session. I think that really sums up really what a constitutional conference is about. Where to in the next few years. So thank you very much.
Kia ora tātou. Peter Mackenzie said we were on a pilgrimage. I suppose it's a constitutional pilgrimage, and we are pilgrims. But I don't think we're in a slough of despond. I think it's really important to recognise at the beginning of any constitutional discussion that New Zealand is quite well governed. It has a lot of transparent laws. It has freedom of corruption. It has a politically neutral public service, and it has many things that failed states would need but don't have. So the tapestry on which we are weaving this constitutional picture is actually whether our constitution is fit for the future. And in that respect, I am far from convinced that it is. It seems to me the unfinished character of it is a problem in that respect. I do believe that public policy in New Zealand in the next 20 years or more is going to have to face up to problems that are much more serious than it has so far in its entire history. Climate change is just one of them, but there are many others. I think there's going to be a lot of global instability, a lot of conflict, and a lot of problems. And you're going to need to have clear principles in your constitution. Now, having said that at the beginning, let me give you my takeout of what has been said at this conference. I think the papers have been of a high standard, and they're very interesting. The first takeout that I have is that we're blessed with a very complicated history of two peoples. And the historians who were active in this conference, as they are not in many constitutional conferences, certainly brought a depth of understanding to this that I value. Secondly, we were told it's a political constitution, the boundaries of which are uncertain and highly contestable. And indeed, there was a lot of support for the political constitution in that respect. The third thing is, we were told, it's very hard to change it, very hard and very risky. I've heard that before. And I'm not convinced by it. I don't think constitutional change is very much harder than many other changes. It's just that we lack the appetite for it because we don't know what we want to do. And that's a different problem. Now, the real difficulty with the New Zealand Constitution, from where I look, is that the people who need to understand it and the people who need to think about it are those who are governed under it. And they're not here. This is an elite gathering of highly educated people, and the bulk of the population are not highly educated, and they don't think about the Constitution and they don't understand it, that's for certain. But when I did a program of constitutional reform when I was a minister, I called it open government. I eschewed the word constitution. It's a showstopper. Now, the difficulty is that many of our people just misunderstand how they are governed. There is a real problem in that respect. When I returned to the university to teach public law from politics, the students in public law did not know the difference between a cabinet and a caucus. We have got massive constitutional illiteracy in New Zealand, which has great practical importance because people don't know how they are governed. And that seems to me to present two problems: apathy and ignorance. And they are mutually reinforcing. The Constitution that we have is neither clear nor accessible, and it's very difficult to explain. The prime reason we have a Constitution Act 1986 was that when at the Victoria University I was teaching constitutional law, I was teaching 12 or 15 provisions out of the 1852 Act, and the poor students couldn't make the slightest sense of it. Now could they? That is not a good way to have a constitution. You need to have civic virtue. You need to have people who understand it, who internalise it, who like it, who want it and respect it. We don't have any of those things for our constitution. It's a sort of magical mystery tour. Now, the thing that I hope will come out of this constitutional consideration, if anything does, the thing that I want most to come out of it is a program of education, because this is a defect in our schools. In any democracy, you need survival skills about how the democratic system works, who your MP is, what your MP can do, how you can function. We don't really have that, and we haven't had it for years, and I've been fighting a battle for 30 years and got nowhere with that. Now, I do want to say a word or two about what Professor McClay said, because I think the real difficulty with his remarks is this. We have a political constitution, so just about all the argument about it is going to be political. You can't fence law off like that. It can't be done in a political constitution. A lot of the constitutional conventions are highly contestable. Sometimes they're followed and sometimes they're not. Nobody knows what they are. Jim McClay invented a great one to prevent a devaluation crisis. It came from Australia. Now, I don't think that that degree of indeterminacy is terribly desirable. And indeed, when I share a platform with Ken Keith, as I've shared many of them over the years, we first shared a platform on constitutional reform in 1968, 45 years ago. Now, what has happened since then? We've had quite a lot of things. We've had the Ombudsman. We've had the 1975 legislation about the treaty. We've had the Human Rights Commission. We've had, indeed, the lettuce patent that Alison Quinton Baxter. That was a very important change that was done then. We've had an Official Information Act that Ken worked on that's made things much more transparent, although the politicians don't like it. and they won't accept the Law Commission recommendations about it. We've had the Constitution Act 1986, we've had the jurisdiction of the Waitangi Tribunal extended to 1840, we've had the Bill of Rights, we've had the Regulations Disallowance Act, we've had the Supreme Court Act. We have had a lot of constitutional change, and that is important and valuable. But I say to you that there is great need for more progress. I think the time has come in New Zealand to have an entrenched superior law constitution from which, very similar to that advanced in the 1986 white paper on the Bill of Rights with the Treaty of Waitangi in it, and with some of the conventions of the Constitution probably as well. And we need a heavy dose of parliamentary reform as well. We haven't had that for more than 20 years. And I think that we could, if we thought about it really carefully, engineer those changes. They are not impossible. They are only impossible if you think they're impossible. They are, of course, difficult and they will be controversial. But the thing I learnt most about constitutional reform in New Zealand as a minister was that it requires ministerial leadership. And I don't see in the Parliament, on any side, of any party, any appetite for constitutional reform at all. And of course you wouldn't, would you? Thank you.
Professor Geiringer, colleagues, ladies and gentlemen, how do you follow that? I'm conscious of being, as I stand here in the presence of two of our constitutional giants, Sir Kenneth and Sir Geoffrey. No mention has been made, I think, of the Cabinet Manual, which I think Sir Kenneth was the originator of and certainly one of its major authors. The United Kingdom now has a Cabinet Manual. They got very worried just before the last election that it looked as though there was going to be a coalition government. So the Cabinet Secretary came out here and said, how do you guys manage it out here? And well, we've got a Cabinet Manual. The UK now has a Cabinet Manual, and there's the author of it just there. Sir Geoffrey, in an almost throwaway line, made reference to the Bill of Rights Act. I mean, he's its author. He's the one who drove it through in our Constitution. It struck me enormously as I come back to New Zealand just how influential he has been. I mean, he not only abolished the action for negligence in personal injury cases, just did it. And then he drove through the Bill of Rights Act. I was saying to one of my colleagues yesterday, but he's never actually been the Dean of the Law Faculty. They said, no, but he has run the country. I was also made conscious in the remarks of Philip Joseph of what my shortcomings as a lecturer were back in the early 1970s when I lectured him on constitutional law. It is perfectly true that in those days we didn't make any reference to the Treaty of Waitangi. Those things are greatly changed. And I can remember discussions with a friend of mine, a man called Peter Adams, who subsequently came back here and was a very distinguished civil servant in foreign affairs, who was doing a doctorate at the time in New Zealand's history, written from the point of view of the Foreign and Commonwealth Office in the UK. He's subsequently written a book called Fatal Necessity. I commend it to you. It's a wonderful account of why the British didn't really want us as a colony. We were a damn nuisance. Ever since they were busy losing more colonies in North America, the last thing they wanted really was another one, which was going to be troublesome. Those are some introductory remarks. My deanly duties have been such that my opportunities to attend many of the sessions of this conference have been limited. Today's the day when I have to put in my annual budget. That's what deans have to do. But the magic of Dropbox and so forth means that I have been able to read some of the papers and my discussions with people who've attended lead me to think that it has been an extremely stimulating event. I did watch the address of our ever-thoughtful Chief Justice on live stream, and I was watching Andrew Sharp's presentation on tradition when it came to a rather abrupt end yesterday morning. I've yet to interrogate him to find out how it all ended. I want to pay a small tribute to Andrew Sharp, though, if I may. I was a junior lecturer at Canterbury, lecturing Philip Joseph Badley, when Andrew returned from his doctoral studies at Trinity College, Cambridge, to lecture in politics in the early 1970s. The ease of relationships was such between the disciplines in what is now the Arts Centre, which is where we were based, that our paths actually crossed quite regularly. And it included the playing of a certain amount of squash and other important things such as that. And over a beer after one of those games, I confessed that I was struggling to come to terms with the works of HLA Herbert Hart, which I needed to do for the LLM in which I was then enrolled while I was a junior lecturer. Andrew said that he would reread The Concept of Law, which was Hart's major work, and we would discuss it later. He was as good as his word, and discuss it we did. And it was of a piece with what Mark Bennett said in his introduction to Andrew's session at yesterday's first lecture. All of it just suddenly became clear. So that's what he's on about. Hart was working in the context of linguistic philosophy, which Trinity philosophers, and Andrew was at Trinity, were the groundbreakers, Wittgenstein in particular. Now, I'm sure that I've thanked Andrew personally before, but I'm delighted to be able to thank him again and publicly now. The conference has been about unearthing our constitutional traditions. And as Geoffrey said at the beginning of his paper, we've perhaps not done enough of that in our scholarly writings, and there's been no modern work that seeks to do this. Now there is a hint to my junior colleagues. There's a big project to be done there. It's waiting to be done. But Sir Geoffrey does cite Height and Bamford, an early book on our constitutional history. And it's a work I look at from time to time. I think it's a very good book, limited, but nevertheless a very good book if you're looking for explanations of features of our Constitution. I was reflecting as I was sitting in my office over in old government buildings, that building is in fact a part of our constitutional history. It contains our first Cabinet Office. And I wanted to know why it was that the provinces were abolished in favour of a national parliament. As you know, next door we've got what used to be the Wellington provincial legislature. And the story is there in Height and Bamford. It really is a book that is well worth consulting from time to time. And the answer is that better means of communication, greater ease of travel, made independent provincial legislatures a luxury in a sparsely populated country such as New Zealand. One of the papers that caught my attention was devoted to the first Chief Justice Martin, by Peter Mackenzie. It gives a graphic and I think fascinating account of the difficulties that were faced by a young man, and he was young, I think in his 30s, charged with the task of bringing the rule of law to an extremely unruly new nation. He'd have been a good dean, I think. But he was the first of the Chief Justices, of whom there's still only, even counting Dame Shan, there's still only ever been 12 in our history. And when I was back in Cambridge recently, I checked with the archivist of his college, St John's College, which was incidentally the College of Maclaurin, the first dean of our law faculty. And there is actually quite a lot of information about Martin in their archives, documenting in particular his relationship with Bishop Selwyn. I happen to be extremely interested in the third Chief Justice, James Prendergast, whose biography is about to be published by Grant Morris, and whose most famous case, We Parata, has been the subject of a recent book by David Williams, whom I'm delighted to see here with us for this event. Prendergast matriculated at my college, Gonville and Keys. It can be found in the college's biographical history. It's an 8-volume document which records every student who's been matriculated since 1348. when the college was founded. And it includes the details of the parents, the mother and the father, what they did, where they lived, and so forth. It's an astonishing document. And Prendergast is recorded there. But 3 months after he matriculated, he's writing to his father from a different college, Queen's College. Now, that nugget emerged from a footnote in an article written by Grant Morris, which referred to some correspondence between Prendergast and his eminent father in London. His father was a QC and the recorder of Norwich. And believe it or not, that correspondence is to be found in the National Archives in Molesworth Street. And it's fascinating. And it shows that Prendergast decided, after a very short experience of Cambridge, that he wanted to become a fellow. He was going to become Don. And in those days, and it was true until after the Second World War, the Dons were selected only from members of their own college. And he discovered that the Fellows of Keys were paid rather less than the Fellows of Queen's. So he jumped ship and went to Queen's. A quite astonishing thing for an 18-year-old to do. I mean, most unusual even then, but it gets better. Because in one of his letters to his father, he complains that the authorities in Queen's made him take his meal at 4 o'clock in the afternoon. And he didn't want to eat at 4 o'clock in the afternoon. And as he put it in his letter, if those swine don't change their minds and feed me at a more appropriate time, I'll take myself off to Trinity. When he could have been a predecessor of Andrew Sharp and Wittgenstein. In December, I'm going to give the annual Robin Cook lecture, and it's tentatively entitled New Zealand Law Now. What I want to do is look at the evolution of New Zealand law and the institutions by which it's created and administered to try to offer a snapshot of the forces and influences that have shaped New Zealand's law. And it will, I think, in a way, pick up on some of the themes of this conference, our constitutional traditions, why we have a unicameral legislature, why we have a Supreme Court and no longer recourse to the Privy Council, what happened when the United Kingdom decided to join the European Economic Community as it then was in 1972. I think one of the biggest influences on this country's history for a very long time, the dual impact being that the House of Lords was no longer the highest court in the common law world. That's now the European Court of Justice. And to a lesser extent, when Britain signed up to the European Convention on Human Rights and instructed its courts to, quotes, have regard to, and that's what it says in the legislation, have regard to the jurisprudence of Strasbourg, forces were put in place that have ramifications and repercussions for this country far away. So it remains for me, I think, to offer thanks to all of you for coming to this event, to the speakers in particular for the work that you put in to making this such a memorable event, and to the organisers, Joel Colin-Rios and Mark Bennett and Claudia Geiringer and their colleagues, and to Anna, who has worked behind the scenes to make sure that we all turn up at the right place and at the right time. Tēnā koutou, tēnā koutou, tēnā koutou katoa.
We've got plenty of time for discussion, and what I want to suggest is that it would be appropriate if you have questions or comments on anything the panellists have said, but in addition, I'd just like to open up the floor for anybody that has anything that they'd like to reflect on about the overall themes of the conference, or that they think that the panellists might like to reflect on. Now, I've been performing the important role in this conference of microphone girl. I'm hoping somebody else might step into the gap. Thank you, Joel. Who'd like to get us started? I notice Kiwis never like to be the first one to put their hand up.
Stephen Sutton, lawyer at Russell McVeigh. It's a reflection, and then I would welcome any comments. One thing that seems to have been bubbling away throughout this And the comments just now about the abolition of the provinces has reminded me of this again. One thing that has not been mentioned in the past 2 days, and that's not a problem, is the fiscal state itself and the effect it has on the constitution. And it seems to me that in a pragmatic constitutional arrangement, that the fiscal state is actually very important and is one of those factors that drives, just by the simple fact that there's no money, or that we suddenly find money, a lot of the changes that we've seen, that abolition of the provinces being one of them. In that instance, the, I guess, borrowing of the provinces and the desperate need to raise more capital at that time for public works projects. I wonder if that is a coherent theory and if anyone else has any comments on that.
Responses from the panel?
The Public Finance Act of 1989 was an enormous change in the way the government handled its money and its accounts. It produced a different accrual accounting, and you had to count for assets. I remember as Minister of Justice, the farms that I had suddenly came in to the accounts and they weren't producing anything, and they were, there were a whole lot of problems of that sort. I think that was a very big change. I think the government's finances are stricter than they used to be, but they're harder to follow. It's very much harder for the MPs to scrutinise government expenditure under accrual accounting because the votes don't really mean what they used to mean in a cash accounting system. And I think there are a set of problems about finance and accountability. I think the MPs have to work much harder, and it's very difficult for them. And I think there are some problems with the parliamentary side of the appropriations now. But just to say a word about the provinces, in the work that I was doing for the paper, I got into the provincial politics of Nelson for quite a few years and through papers past, and they were fascinating. It was much more lively sort of politics than has ever happened in Nelson since. It was, for Nelson, a great loss that the provincial legislature ever got rid of, because it was unbelievably active.
Professor Smith?
No.
It's a good point, Steve. And I was just thinking that the Constitution Act, which we've mentioned, that was driven, I think, by an immediate fiscal crisis, wasn't it? The reduction to devalue the dollar by 20%, and of course Muldoon, having lost the election, refused to do that. And Geoffrey then expanded the terms of reference so as to develop a consolidating statute, which is now, of course, the Constitution Act. But if you think about more recent reforms, the Bill of Rights Act, that wasn't driven by any fiscal imperative, nor the Supreme Court Act, that was simply to patriate our judicial processes. And MMP, of course, which was probably our greatest reform, having the greatest impact on the way we do the business of government of any measure, had nothing to do with any fiscal imperative. But right, with the provinces, that was driven because they were seen to have outlived their usefulness in that regard, yeah. So some yes, some no.
Another question?
I'll tell you a Ken Keith story, though, about this. Since Phil mentioned the devaluation crisis, I had to get Ken to write an opinion about whether, despite the provisions in the Civil List Act, whether the government could be changed as a result of the difficulties that we were encountering, and whether the Governor-General would be able to swear in a new government even though there weren't any MPs. And Ken wrote a bold opinion, still in my possession, saying yes.
That would be a bold opinion.
I think the Governor-General actually accepted it.
I'm Jelena Gligorievich, also from Russell McVeigh, and I've got a comment and a question for the whole panel stemming from Sir Geoffrey's speech. I agree entirely that fundamental to our constitution is an understanding of it by the populace, and that if there is anything wrong or that needs to be done about our constitution, it is to educate ordinary New Zealanders about what's in it and how they stand subject to it. In fact, I think the only way to facilitate achieving the aims of Matthew's aims is to educate ordinary New Zealanders about the rule of law. So my question is the only way to achieve that level of education, to embark on that process to entrench our constitution? Is that what has led you, Sir Geoffrey, to advocate for the entrenchment of the constitution?
No, in the sense that I think that the education is a necessary prerequisite before you do it, so that people understand what it is that you're doing. And since the level of understanding, at least in my experience, is so slight, I think you can't, I do think that when you have such a constitution, it would be much easier to teach in primary school and secondary school. And most other countries that I've lived in, such as the United States and Australia and England, they have got a better understanding of these matters. And that's surprising, because New Zealanders are well educated and up with world affairs and are good in many respects. They just don't have a clue how they're governed.
Just a quick comment on that. I've for some time thought that there's scope for an appointment to my faculty of somebody whose role it would be to explain our constitution. It's something that when I was responsible for the School of Government, as Pro-Vice Chancellor for the School of Government, I used to talk with people there about the possibility of, securing funding for that. I think it is important. And I suppose my other comment would be, allied to Geoffrey's, there are very few journalists who seem to understand our constitution. Some do, but very few, and some, such as the one who's at the centre of the particular storm that's going on at the moment, says some quite astonishing things about the position of the judiciary in our constitution and so forth. And I think if the professor of my desiring were to be required to focus his or her attention, it would be directed first at the journalists.
I mean,
One thing that the then Prime Minister asked me to do was to write an essay on the Constitution of 5 pages or fewer for the Cabinet Manual, and it's still sitting there with just a few amendments. It's been there since 1990, and it seems to me still to be fairly good. Well, it was carefully edited and carefully gone over, and it's been slightly amended to take account of MMP and so on. But there, I think, is a, if I can say it myself, a rather clear statement. Now, thinking back through my schooling, in social studies, when I was 11 or 12, we got a lot of teaching about Parliament. And one of the few things you could listen to on the radio really was Parliament. And we knew about local government rating. And I asked one of our granddaughters, who's really bright and very well educated in many ways, and who's about to go to high school, what she knew about the way we were governed, and she pulled a face, I think. Not quite, she's a very, very nice young lady, but she didn't have the slightest idea of what my question meant. And so I think there's a huge problem just, I don't know that it's that huge, there's a problem at the primary school level. And a number of you will know Roger Clark really well, and in the late 60s, I think, Roger produced a bulletin for schools, which is about the Constitution of New Zealand. It's rather long and slightly difficult in some of its parts, but that's what the Education Department then was about. And it's something, I suppose I've got the excuse that I've been away for ages and haven't necessarily seen the right people, but I would have thought that it was a pretty straightforward thing to include in the social studies program. And in terms of Tony's new professor, I'm sure that the Cabinet Manual will quite happily hand over those 4 pages. In the latest version I saw, I don't know if it's been edited, but it is rather straightforward. It's a rather straightforward document to describe, and it does relate to the story about the Cabinet Manual. That there is a lot of stuff there that states pretty clearly the way in which government should work, and the way in which treaty issues should be addressed, for instance, and the way in which legislation should be prepared. Very clearly written stuff, a lot of it. So the material's there, but there is a real deficiency in the education system. And when I used to teach constitutional law or public law or whatever too, I'd ask people how many of them had that morning listen to Morning Report, and almost no hands at all would go up, you know. So
I've got very little to add to that, except I'll give one illustration of just how woeful the knowledge is of students coming into my public law class in their second or third year at university. We have our mid-sessional examinations at the beginning of the second term, and I've had to put my mid-sessional back to halfway through that term because I don't have enough examinable material, because I spend the whole first term talking about terms that they've never heard of, like Geoffrey mentioned cabinet and caucus. They've never heard of these terms. So it's a real series of building blocks. And I realised this after about 10 years of beating the head against a wall, because the students would come to me before the exam and say, where are we going in this course? What's going on? And I said, where have you been all this time? I mean, I've been lecturing you, know? So now I just pull right back and start from basics, and it does take that much time, because you are really talking to people with just no knowledge whatsoever. Morning Report, they'd say, what?
Some of my second year students are catching my eye guiltily as you speak, Philip.
Yeah. What is worse, if I may say so, is that public servants have no understanding of the Constitution either.
Got somebody at the back here, I think. Yeah.
Kia ora koutou. My name's Stephanie, I'm from Wellington. A key question that has been in my mind over the last couple of days of the conference that we haven't squarely addressed is who gets to design the Constitution. And we've talked about a mainstream constitution and a other kind of constitution which has various aspects, and sometimes that has had a Māori aspect, sometimes called a whakapapa, or a tikanga based aspect, which is different from what we call the mainstream constitutionalism that we've been discussing. We've also been reflecting on elitism and talking about various groups of us, and sometimes the people in this room as a particular elite. And just with those things together, I've just been thinking about this question: is it a constitutional question? Is the question who gets to design the Constitution a constitutional question? And I wondered if you had a view on the importance of that question and whether you think it's a constitutional one. And the second question is, should we be thinking more about a constitution that does better at marrying these two or various ideas of constitutionalism? And that's an idea for the panel.
Okay, I'll kick off since the microphone's right in front of me. If you look at the history of modern states, they have adopted constitutions out of crisis, essentially, a response to immediate needs, out of defeat through war or desire to unite or to secede or whatever. And I'm just thinking that the only example I can think of a constitution being adopted without that sort of exigency imperative would be Canada in 1982. And just sort of going through my mind very quickly, what were the driving forces behind Trudeau's package, which he managed successfully to adopt in 1982, which actually gave them a patriated constitution? Perhaps Geoffrey might be able to reflect on that, but that's the only example I can think of. Or perhaps you've got another example, have you?
No, I was just going to answer your question.
Oh, okay.
Quebec.
Oh, the answer is Quebec separatism, which is kind of 1980 referendum. It was a crisis.
Yeah.
Why aren't we the ones who make the Constitution? It's us.
Well,
We're the people.
yes.
Why are we not doing it? Why did we not all meet here today and discuss how we build a Constitution?
Well, it's interesting that in...
The answer, Miranda, is because
We've
we've
had a
had
go.
many conferences doing that.
In the United States, they have constitutional conventions that are quite different in scope from what we understand by that term, in which in some states they elect delegates to a constitutional convention, and the convention sits to make the state constitution. And that proceeding is very complicated, very interesting, and sometimes quite futile. What you actually need is a level of public participation in it, and that is very important. But you probably get better public participation when you have got a series of concrete proposals that people can make their views known on. I think the best way to organise a constitutional change in New Zealand, and you wouldn't want to do this until there was some sort of political consensus that this was a good idea, and I don't think that exists. But if you did, you'd set up a Royal Commission. That's what you'd do, because the big
All right, the point's been made, and
I think that point's
does the panel want to respond?
perfectly right, and that's why I mentioned Roosevelt's Four Freedoms. I mean, and the second half of the Universal Declaration of Human Rights. Great speech by a former dean of this law faculty on the adoption of the Universal Declaration of Human Rights. Colin Aikman had written it back in 1948 for Peter Fraser. Peter said, "Colin, this is so good, you give it." And the second half, the central part of that speech is exactly the point you've made. But just getting back to your question of process, just thinking of some of the processes we've been through, they have been very open and transparent. The Bill of Rights proposal was in a party manifesto in 1984. The White Paper was prepared in 1985. The proposals were the subject of a lot of meetings around the country, a very lengthy parliamentary process. And an amended bill was passed in 1990, so it had taken 4 or 5 years to go through that process. The official information reform started, I think, in 1977, and took a rather long time with a lot of submissions, a lot of representations, a lot of written submissions, and it took 3 years, that process. The MMP process started in 86. The Commission toured around the country, went to lots of places, went to a great number of Marai and so on, and ended in with the 2 referendums in 93. So that was 7 years. And actually, just in terms of that process, there's a great story right at the beginning. The Commission was at Turanga Waiwai. David Lange, as Prime Minister, spoke. This was a very early meeting. Someone got up and said, "Prime Minister, you've got the votes. What are you doing messing around with these jokers? Why don't you just fix it yourself?" And Lange, without a pause, said, "Asking politicians to design an electoral system is like asking panel beaters to design intersections." So that highlighted really well, I think, the question of what is the correct process, and the correct process will vary from one situation to another. In that document I was modest enough to mention, there are actually 2 paragraphs about changing the Constitution, making the point that some matters will evolve out of practice, like the work of Jim Macleay and Hugh Templeton too, I think, over that really difficult evening. It wasn't helped by the weather, as I remember it. It wasn't helped by the fact that the outgoing government had actually decided to have an ANZUS meeting in New Zealand that weekend. So Secretary of State Schultz turned up in the middle of this rather difficult time. So there you got a constitutional convention on the run, but it was one that was based on principle, that there had been, the people had spoken, and the new government, whether lawfully in office then or not, should be able to make the decision, and that's in the end what happened indirectly through the processes that were worked out by the Deputy Prime Minister at the time.
Rachel?
Hi, Rachel Hayward. I hesitate to make this point now because we've moved on, but I don't want to return the panel to their state of despair about civics. But it was a comment in response to that, was my experience of a few weeks ago coming home to find my Year 9 daughter scribbling furiously, and when I said, "What are you doing?" she said, "We're doing a unit on how to effect change, and I'm writing a submission to a select committee on the psychoactive substances bill." So I think the despair about what young people know or don't know might be a bit misplaced. And following on from that, I was going to say, I know there is a degree of scepticism about the constitutional review, but one of the things that I have really enjoyed in the last 12 months is seeing large numbers in some places of ordinary people enthusiastically trying to find out what the Constitution is and engaging in that constitutional conversation. I think there has been enormous value in that, regardless of whatever the outcome of the review.
Do any of the panellists want to respond to that? Well, I'm actually going to wrap up the session. I know there are many more people that would have liked to add their question or comment, but it's been a very long 2 days. You've been an amazing audience, very patient, very attentive. We've heard some wonderful papers. I'm going to hand over, once I've wrapped up this session, to my colleague Mark Bennett, who will very briefly say a few concluding words. But what I'd like to do first is to thank the panellists. What an incredible collection of knowledge, experience and perspective, and we're very grateful that they've taken time out today and over the last 2 days to be with us. Thank you.
So as Claudia mentioned, I've got the job of saying a few words and closing out this conference. One thing that just, I'll take the opportunity to say, because it came up in that last session, I've heard Sir Geoffrey talk about education as the key to this a number of times, and I totally agree with him. And we've seen there's glimmers of hope. I can offer my own personal glimmer of hope is that we used to listen to Radio New Zealand national program every morning, Morning Report, and my 3-year-old son is always quizzing me. Who's John Key? What did he do wrong? And I say, he's the Prime Minister. What's a Prime Minister? It gets too complicated for a 3-year-old. I just say, well, he's in charge, he kind of makes the rules, sort of, and we'll get to the actual nuts and bolts of it later on. But I do think there's glimmers of hope there. I would second the idea, I think that was implicit in one of the comments, is that I personally think we've got all this energy around republicanism. Let's make, Dean Knight will hate me for this, but let's make ourselves a republic. It's really important. I think the most important issue about public participation and having an effective and good use of public power in the society is inequality and poverty, the ability of people to be educated about these issues, to have the opportunity to participate in government. That's a difficult thing to do, to be able to write a submission to a select committee, to have the kind of understanding that's necessary to make sense of what's going on and to provide an opinion that is going to be convincing to a politician. So I personally believe that it's an important thing to think about in a conference like this. Okay. The thing I was going to say before I happened on those thoughts was I think this conference has been a great success. Now you might say, well, you've got a pretty large barrow to push in that statement, given that you're one of the co-organisers of the conference. So I'd like to give you some reasons why you might believe me on that. First of all, a lot of you have said that things have gone well and you think that it's a success, and a lot of you have much more authority in terms of adjudicating on how good a conference has been. The other thing I'd say in terms of a more substantive analysis is that when I was corresponding with one of the participants in the conference, they sent me their paper and I said, great, thanks, looks fascinating. And the response was, don't know about that. I'll try and keep the dull parts to a minimum in my presentation. And then Geoff said that a lot of this history in general and in constitutional history in particular is seen as a dull practice done by dull white men, or dull academics in general, I guess. And so what I think has been successful in this conference is that we've taken sometimes seemingly arcane subject matter and shown how it's important, how understanding it is important, how the different ways that we can look at it and analyse it and use it to make sense of what we've done in the past are important, and how important they are for people trying to make sure that the use of public power goes on in the right way now. And that Geoff himself was very clear that knowing our constitutional tradition so that we can hold the people who exercise public power to account is a very important thing to know. Okay, the other reason why you might believe me that this conference has been a great success is that although I helped to organise it and bring you all to it, it's not just to my credit that it's been a success, it's to all of your credit that it's been a success. Our delegates, our speakers, the chairs, our rapporteurs, all of you have contributed to its success, and you probably will agree with me if I point it out to you, because you share in the success that we've created here. Okay, I did want to tell you, now that I've convinced you that this conference has been a great success, that we have sent flowers and a note to John Martin, the man who collapsed in that first session, on behalf of the delegates and of the conference. Okay, last thing I want to do is we've thanked everybody. Claudia's thanked people, the Dean has thanked people. The last thing that I want to do is thank the person who made sure that this conference, its build-up and its execution have run as smoothly as they have, and that's Anna Burnett. So we've got... So thanks again for all of your hard work, Anna. So with that, I'd like to send us off into the evening to continue our thinking about the Constitution, our engagement with our friends, our families, our colleagues about these issues, and keep that conversation alive outside of these walls. So thank you.